Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is how and when FRAND can be an antitrust issue, a conversation with Lisa Kimmel on the fundamentals. Fair, reasonable, and non-discriminatory, or FRAND, licensing of patents has been the subject of much academic debate and commercial negotiation and litigation. In this episode of Our Curious Amalgam, we provide a nuts and bolts primer on this important topic. Joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Christina.
So FRAND 101, why are we talking about it?
Well, we actually learned this the hard way. We tried to bring people up to speed about the FRAND issue and development. Then we realized that people actually do not know what FRAND is. So we think it's probably time to take a step back to think about the fundamentals and to actually have that re-thought out with the expert. So that's why we're here talking about 101 of FRAND.
Great. And who do we have as our in-house expert today?
Well, our guest, Lisa Kimmel, is a senior counsel in Crowe & Moring and an antitrust expert focusing in particular on the technology and digital commerce sectors. Prior to joining Crowe, Lisa spent 5 years in the Federal Trade Commission, where she worked as an attorney advisor for commissioner and later chairwoman Edith Ramirez. Lisa is a leading practitioner and expert on competition and IP, including antitrust and competition policy issues associated with standards development and standard essential patents subject to a FRAND commitment. Lisa earned her JD and PhD, very impressive, in economics from University of California, Berkeley. Lisa is also an active member of the ABA Antitrust section, where she is an incoming editor for the Antitrust magazine. She is also a vice chair for the American Intellectual Property Law Association. You may know it as AIPLA's Antitrust Committee. So we're very lucky to have her.
Wonderful. Well, without further ado, Lisa, welcome to the program.
Well, thank you very much for having me.
Well, Lisa, it's our pleasure. So as we promised, we're going to actually spell out all the acronyms. What is FRAND? What is SAP? That's probably important for many members of our audience. Why don't we do that?
Okay. Well, let's start off with that. So FRAND is an acronym that stands for fair, reasonable, and non-discriminatory. And sometimes you may hear RAND, which is reasonable and non-discriminatory, and they're just acronyms. And I think what we're talking about here is the application of these concepts to the licensing of standard essential patents, because I think you see the term fair, reasonable, and non-discriminatory, and reasonable and non-discriminatory in many areas of law, in statutory language. So I'm not talking about all of that. I think we want to make sure that we're talking about the application of these concepts in the standards development arena related to standard essential patent licensing. So in that context, and FRAND and RAND, the difference between the two is that the FRAND, these are terms that are part of the patent, the IPR, intellectual property rights policies for standards development organizations. And I think it's just an international difference that European organizations tend to use FRAND, fair, reasonable, and non-discriminatory, and U.S.-based organizations tend to use reasonable and non-discriminatory. I think that's really, the one of the largest standards development organization, ETSI, European Telecommunications, I should know that by now, standards organization that is involved with setting a lot of the cellular standards. They use the term FRAND in their patent policy. Some U.S. I think if you remember the old case Rambus, it involved a standards development organization called JDEC.
Yep.
And I really don't know all the acronyms, the full name, but theirs was a RAND policy. So I think that's where you see the difference is. It's just depending upon how the particular standards development organizations patent policy, what term they use.
Right. FRAND or RAND, I think the spirit is that to have a good standard, like fair, all these like good principles that we want to be implemented in. So it's fair to say it's a standard that when a patent holder and a patentee are trying to negotiate a rate for the licensing. But again, in what context would we be seeing FRAND or RAND negotiations or license being applied? Like in what sectors or industries?
Sure. Well, I mean, I think I think we need to step back. I mean, this all comes up in the context of the development of standards. So there are private organizations, private consensus-based organizations called standards development organizations. And there's a lot of them. They develop standards. I'm most familiar in the technology sector, in wireless communications, Wi-Fi, cellular, 5G. I think for audio technologies, so there's various standards that allow products to connect and interoperate, so that my cell phone can talk to your cell phone, and I can get the audio and the video can all come in. So these are all done through the development of standards, and that's through these consensus-based organizations, and there's many of them. And oftentimes, the way they put a standard together is compiling, it's a document, an actual document that describes the technical requirements for interoperability. And often those technical requirements that the standards development organization puts together will include technologies that are covered by patents. So standards development organizations, which they want to, ensure that their standards get used and people can develop it. So they need to figure out, well, how are we going to determine access to when technology that's contributed is covered by a patent, which of course gives the owner exclusive rights. So these organizations develop policies to deal with that. And there's a wide variety of policies. Many of them, particularly the largest ones in the communications, information and communications technology sector, use a sort of FRAND, and I'm just going to say FRAND. It could be RAND or FRAND, but I'm just going to say FRAND, a FRAND-based policy, which is essentially they ask firms, if they want to include a technology in a standard that's covered by a patent, they ask the firm that owns this patent, will you agree to provide access to implementers of the standard on fair, reasonable, and non-discriminatory terms? And then if the patent owner agrees, that becomes part of they submit something called a letter of assurance.
I think sorry to interrupt. I think we're getting too much in the weeds. So several things. Let's just recap a little bit. So FRAND is a framework. You organize commitments for things in the context that you want the devices talking to each other. And that framework for commitments is essentially developed by the industry itself on a voluntary basis. And the SSOs or SDOs are the organizations that organize these efforts for this framework. Is that right?
That's correct, and that's where you see the FRAND policy come up in these private organizations, and it creates a contractual commitment from the patent owner to the standards body, and then third parties that implement the standards have rights, contractual rights as third party beneficiaries.
I think that's very good. And we'll definitely get into the issues about like what you just described, like in how the process actually plays out, right? How the SSO is asking the patent owners to give their assurance that they were licensed under FRAND terms. But
Sure.
let's on a very high level, can we get a sense, is FRAND getting more or less useful? Like in a sense that they are more widely accepted, or I'm just trying to argue from someone who is like having very little knowledge about, or because the principles are so broad and vague, in a sense, they become something that's like, just blank. They don't really give meaning. Could that be the case? So what's your take on this?
My take is no, that the FRAND framework that these SDOs develop is designed to sort of follow industry practice and provide a degree of flexibility. Because you have to understand that these standards bodies, they're voluntary organizations. In a way, we all like to talk a lot about platforms these days.
Right.
And in a way, standards development organizations are platforms. And they have to draw the interest of both folks that want to implement standards and folks that are willing to contribute standards. So just like a platform has to set a price or rules to balance the interests of both sides of the platform, so do these SDOs. So I actually think, to the extent that interoperability and standards development becomes more important as we want more and more devices to interoperate, that this kind of flexible framework that will draw the interest of all parties will become more important as we go forward.
Yes, I think that's very insightful. So as you compare it to a platform, like you have like groups on two sides. Here we obviously have someone who is holding a patent, or someone who owns the patent, and then someone who wants to implement the patent. But one thing that I think it's probably good to observe is that a lot large companies, they play both roles, right? They have some patents that are essential to one standard, but they don't have all of them. So some of that are held in someone else's hands, and then they want to, if they want to adopt a standard, they want to use the standard essential patents. Like as the group, they would be implementer for some of that. Is that right?
That's certainly true. There are many firms, maybe even most of them, that are both contributors to the standard and also, implementers of the standard. So that's certainly true.
So does that impact how the process of SSOs and then how standards are trying to get the FRAND negotiations going through? How does that, like the dual role playing, does that make a difference?
Well, I mean, I think it depends on, I think it, gives an incentives for all parties to sort of, take the overall mission of the SDO, and I call it a standards development organization rather than setting organization, because there are reasons for that. But I think that it creates more of an incentive for everyone to take the mission of the standards development organization, which is to create successful standards that are widely used, into account.
That's also helpful. So I guess we already touched a little bit on the second bucket of topics that we want to touch is when can conduct by anyone, like implementer, patent holder, or even standard organizations get into antitrust problem. So when could that be a real possibility? So we often hear hold up, hold out. What are those conduct?
So I mean, I think the first thing to say is the antitrust rules are the antitrust rules. There's no special antitrust rules for standards development or FRAND. Right. So I think, it's the antitrust laws as we have them, and we'll see what happens to that within the next a lot of activity there on basic principles. But we do hear these terms hold out versus hold up a lot. And I mean, we could spend an awful lot of time. I don't want to get too much into the weeds, but it's usually hold up is this. It actually, and you'll indulge me a minute. Hold up is an economic concept, and it comes out of literature that was developed in economics to deal primarily with vertical relationships.
Mm-hmm.
And a lot of it comes from the work of a former Nobel Prize winner, Oliver Williamson,
Mm-hmm.
who I happened to actually be a research assistant for when I was in graduate school. So it had to do with this notion of lock-in, and it was really based on physical assets. So if you own if you decide to build a manufacturing plant, and you can build it anywhere in the country that you want before you actually build it. You have a choice, but you're going to need access to some kind of, let's say, mineral, like, or something where you, as an input, you need it to be near, using really old-fashioned example, but like a mine or something like that.
Right.
And the transportation costs are very high to get this input into your factory. So you want to build close to somewhere to reduce the transaction cost.
Mm-hmm.
At the point before you build, you have a choice where you're going to put your plant.
Right.
But once you build the plant, and you become sort of locked in, because now if you can't use that mine that's very close by, you're going to have really much higher transportation costs. So this was a concept that was used to explain why so that would create some certainty. You would be very vulnerable because if you couldn't control your price down the road. So it was a concept that explained why firms might vertically integrate. Why might you decide to buy that mine,
right.
or why might you decide to invest in a long-term contract so that you couldn't get subject to this holdup problem. So it became applied in this context to the idea that once a patent is incorporated into a standard, then the implementer would be vulnerable in the same way that manufacturer would be vulnerable.
Right.
The only difference is that the patent holder's technology is published and public in the standard. So unlike the mine owner, they can't shut their door and say, well, you can't use it unless you pay me more.
Right.
In fact, it's there. You can use it. In fact, the problem, I think, is the other way around, as you're noticing, which is hold out, because the patent owner has given its technology to the standard. It's public in the document, and they actually have to chase down the implementer to get paid. And so I think those are the two issues. So the holdup issue, I think, is sort of a misapplication from literature on physical property to intellectual property, which is much more easily appropriated. And I think that that's sort of gotten root, unfortunately, in the literature. But to get back to your original question, I don't really think that either of them are necessarily raise antitrust issues, which we know are based on either collusion or exclusion, and right now, anyway, under the antitrust laws. So
right.
So
I
just
go ahead.
Stepping back, you had mentioned or described SEOs as platforms. And I can see where when you want to match the patent holder and the implementer together, there are network effects, right? There's benefits that the patent holder wants to do it if the organization has a lot of implementers, and the implementers are similarly interested in adopting the standard if it's industry wide. Are there antitrust issues with that, right? The establishment of these standards, that upon the establishment of the standard, you've created effectively, I shouldn't say monopolist, but it's also a patent holder, so they have a right to that monopoly. But how should we think about that?
Well, I mean, I think it would be the standards development organ. It's the platform, right? That would, over time, probably make it difficult for parties to switch. So if you have a particular standard that's developed, the Wi-Fi standard, and all that, they have to be backwards compatible and so forth. I think it would be, it's the standard that probably, develops some. It would be difficult, to challenge the standard, although I do think it happens. So I think that's where the network effects come in, that the standard and probably the standards development organization over time could acquire some market power, which I think there was some in a DOJ, the 2015 DOJ IEEE business review letter. They made an argument that there had been some controversial changes to the IEEE patent policy, and one of the things DOJ said in the standards in their business review letter was that if patent holders were unhappy with the standards development organization, they could move to a different standards development organization, which I thought was, kind of not, realistic view of the ability to just move from one standards development organization, because I do think there are network effects and lock in there. So I think that's how I would think about those concepts in this arena.
It's worth following up on your discussion about hold up versus hold out and what Christina was just asking about. So is there any empirical evidence that which one is the real possibility? What happens more? Do we observe any actual incidents of hold out or hold up, and which one is more dominant, I guess?
Honestly, I mean, there's studies out there. I'm not familiar all of. I think these things would be very hard to measure because these are mostly and we don't have. Nobody has great data on. This would be something that would be very difficult to collect. These are private agreements. We can see things that get to litigation. But most things don't get to litigation. So I hear there's no empirical evidence and there is empirical evidence. And I think I'm just going to remain skeptical of empirical evidence on this point, because as an economist, I take empirical evidence seriously.
Right.
And if I was trying to write a dissertation and I needed data, this would not be the topic I would choose.
That's fair. So get back to some antitrust terms that we often hear, like a refusal to deal. I guess that's applicable if you're thinking one side is like trying to hold either out or up, and then you're not dealing with the other side. How is that treated? Given I know antitrust laws are the antitrust laws, as you said, there are no special antitrust laws for standard essential patents. But how are they treated? I guess that's related to our third bucket of question. How have they been analyzed by agencies and courts in these contexts?
Sure. Well, there's been a few big cases. I'm sure you've seen them. I mean, the most recent one is the Ninth Circuit decision in Qualcomm. We saw the Rambus case many years ago, which was really more about deception. But I think it was clear. I think usually the question is a breach of a FRAND commitment, is that raise an antitrust issue? And I think even before Qualcomm, it was pretty clear that the mere breach, it's a contractual issue, and it doesn't raise an antitrust issue unless you meet the other elements of an antitrust claim, which, with unilateral conduct usually requires market power and exclusion. So I think that we don't have that. I mean, I think under U.S. law anyway, there are different international jurisdictions, and I'm not going to pretend to be an expert on that, but for regimes that have different antitrust frameworks that have, an abusive dominant standard may have different results. But in the U.S., the breach of a FRAND commitment does not raise an antitrust issue. And like I say, the Ninth Circuit spoke to that most clearly recently in Qualcomm. But I think that would have been was pretty clear before that.
Yep. So that's definitely a major case. And if people are interested, we can put a link, other than the link that we're going to put to Lisa's paper. Lisa has a paper that's recently published that's talking about FRAND and market power fallacy, I guess. We can talk about that a little bit more. So that's one main type of issues, antitrust issues, the refusal to deal. And then what about a theory that you could have a whole group of people, either this side or that side, and then you collude, and then you collaborate in the sense that's not competing to each other or trying to competing, not in a competitive way. What about that theory? Is that being accepted well in courts or agencies?
I mean, standards development itself is a collaborative activity that often involves competitors.
Right.
And, but it's treated under the rule of reason and considered pro-competitive. And, this doesn't have to do with, interoperability or technology standards, but the well-known case, I think it's Allied Tube and Conduit, a Supreme Court case, and there's good language about that there. So standards development itself does involve collaboration, often among competitors, to set a standard, and that necessarily we're going to agree that these things are in the standard and other things are not in the standard. So that raises some antitrust issues. But like I say, the Supreme Court's been very clear that, the pro-competitive benefits of standards development outweigh any costs. Within the standards development bodies, there can certainly be issues. I think most standards development bodies have, along with their patent policies, they have antitrust policies that, prohibit discussion of price, because you've got firms that are selling the same products and you don't want them using the standards development process as a way to collude on downstream prices and things like that. Same thing with the firms that are firms that may be potential licensees getting together and saying, well, look, this is how much we think, is a licensing rate, and we're not going to pay any more than that for that. And that would also raise, antitrust concerns. So I think there are certainly issues that I don't know that there's any of those kind of, and I could be wrong, but I'm not aware of any. It's an issue that comes up for discussion and policy. If you look at some of the DOJ FTC guidance materials, they issued it's a long time ago now, but in 2007, a report. And there's a chapter in there, I think it's like the application of the antitrust laws to intellectual property, 2007 report. There's a chapter in there on standards development, and they provide some guidance on some of the horizontal issues and what you can and can't do within standards bodies. So there are certainly issues, and folks that are participating in standards bodies should get antitrust guidance a little bit if they're a newcomer.
Right.
Certainly, the bigger risk would be, I think the biggest risk is, just discussion of price, among competitors in any trade association, format is raises some antitrust red flags.
That's fair. We're going to invite you to provide us some observation and also try to read the tea leaves. So what have you observed about FRAND litigation in U.S. generally, I guess, in the past decade or so? And then what do you predict would change or not change given the new administration and new leadership in antitrust agencies in the U.S.?
Well, I think the trend in the courts has been pretty clear on the antitrust issues that have come up. And like I say, it's just really standard antitrust principles. And I think we've seen a lot of attempts to try to create creative theories to get the licensing dispute issues into an antitrust framework. I don't think it's been successful. Absent, some legislative change, I don't expect to see much change in the way the federal courts are viewing these issues. With regard to the agencies, I think, we'll take a wait and see approach. Obviously there was, when the change in between the Obama and Trump administrations, we saw, a somewhat, different approach come out. And a lot of it was policy, in terms, there's an awful lot of talking about FRAND and intellectual property rights that comes out of the antitrust agencies. But, I think the only case we saw was the FTC's case in Qualcomm that did not succeed. And so I expect we'll see more talking, and more policy statements,
And notably,
So
Lisa, I think the the executive order that came out in July certainly at least had one line or one reference to encourage the agencies to rethink, the intersection between antitrust and patent, and in particular around SEPs and FRAND licensing. So it will continue to be an interesting space to see and see how it evolves over the course of the next 4 years, either in talk, in actual policy, or in the courts. So Lisa, really appreciate your time today. We wanted to pivot. We ask all of our guests some standard questions that help us get to know you better as an individual. The first question we always ask is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
Yeah, I know. I was actually, of all the questions, it was like the hardest one for me to think about. It's the only one I actually tried to do some advanced planning to come up with. And I think I'm a bit of a news junkie, I would say. So probably the minute I get off this podcast, I'm going to turn on CNN and see what's happened today that I've already missed, because things tend to move really rapidly. And I don't know, over the past, maybe like many of us over the past 4 or 5 years, politics has gotten a bit dramatic. And I miss the times when it was a little like you could go a couple days and figure, nothing's happened today. So that's probably something that maybe people do know that about me, but I'm a bit of a domestic news junkie.
It's like your daily soap opera in the background, right?
Exactly.
And Lisa, do you have any advice?
Except much more serious.
Yes, obviously much more serious, but in terms of the drama and the...
Yes, there's a lot.
Yeah,
yes, there's you never know what's coming next.
And Lisa, do you have any, well, I'm sure you do, but what advice would you give to young professionals or students who are interested in doing what you do?
And you're playing two roles here. You are a lawyer and economist. So I guess for people who are not as talented or determined to get both, they probably would not have as many options as you do. But we would like to hear your advice.
Well, I mean, I think, to try to identify, what it is that you actually find interesting. I think a lot of times we overthink and underfeel, and so if you feel that you enjoy something, you should pursue that rather than, imagine in your head what you'd like to do. I think you should, in many areas of life, when you're selecting your path, you should listen to your emotions a little bit. And one other, this is a personal sort of maybe half advice and half request, that no matter which area you choose of law you choose to enter, please focus on your writing. I find that there's nothing more important in being a lawyer than most of what we do is communicate with written words. And it's very important to learn how to do that clearly and effectively. And it doesn't have to be brilliant, doesn't have to be, beautiful. Some people are excellent writers, but really, really focus on writing. Look, when you're working with people, try to look at those folks that you work with that communicate clearly, model their practices. I think that your colleagues will appreciate that. Writing is a really important part of being a lawyer, and I'm often surprised that we're not better at it.
Yeah, and start early, right?
Start early,
because it is a skill that takes many, many years to refine. So
yeah.
So Lisa, final question, and this is drawn out of a virtual hat. It is our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Lisa, can you pick a number 1 through 25?
Okay, I will pick 15.
15. Okay. What do you wish you knew when you started your career?
Oh, wow. That really, what do I wish I knew when I started my career? That, Gosh, I guess I wish I knew a little bit more about, law firm life, what it takes to succeed in a law firm, and, how to advance, and how to, work better in a large organization like that. I came out of, I spent time in graduate school where you work very independently. And so I think that early in my career, it was difficult for me to adjust to an environment of a large law firm. And it took me in particular some getting used to work on other people's schedules. I'm a hard worker, but I really like to work on my own schedule. And so adjusting to other people's schedules, frankly, it's still a challenge. But so that was something that I wish I'd understood better early on.
And do you have recommendations for our listeners who are sort of looking to enter law firm life on what to expect, or what they can do to succeed in those first years? I think just, really, it's very important to be, helpful, eager, and flexible.
That's fair.
Not inflexible.
Well, Lisa, it certainly has not stopped your career. So again, thank you for joining us today. And to our listeners, thanks for listening into this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.